Brad and I thought what we would do is walk you through several topics in our field in election law, and just sort of explain what's been going on recently, what the controversies are in the states. The first topic we wanted to talk about is what the Constitution has to say about the right to vote, or how the right to vote is regulated in this country. The second topic is about sort of new controversies in election law in the state regulation of voting. The third one we'll talk about is gerrymandering and redistricting, including in Ohio. And then we'll end by discussing the two cases that are currently before the Supreme Court that have to do with election law. I should say, Brad and I are friends in our field. We're of different parties, but we are know each other well. It's fun to do things like this for Granville and for the Granville Public Library. So we hope you enjoyed our presentation. I wanted to begin, and Brad, please feel free to chime in. I wanted to begin at the very beginning with what voting was like at the beginning of the Republic, and how that has impacted how voting is regulated today. So, as many of you know, in 1787, 55 men representing most of the states gathered in Philadelphia for 3 months of the summer and drafted a constitution for our nation. We had a constitution before that called the Articles of the Confederation, but it had lots of problems. And when these 55 men got together to draft this constitution, this is a picture of the Constitutional Convention, and here's another one. One of the things at the very end that they tried to figure out was how the new constitution would regulate who can vote. And this was very controversial because the states before that time were very different from one another, and they regulated voting very differently from one another. And so the framers couldn't agree on this issue and kind of decided to kick the can down the road. The Constitution itself said very, very little about voting. I can show you in this next slide what it did say, but as the header of the slide says, the right to vote isn't guaranteed by the federal Constitution. The right to vote is guaranteed to citizens of the United States by their state constitutions or by their state governments and by a bunch of court decisions. Here's what the Constitution actually said about the right to vote, the original Constitution. Very little. One thing the Constitution said is, however, whatever method is used by the people of the several states to elect the most numerous house of their state legislature, the same method will be used to elect the members of the U.S. House of Representatives. So remember, the Senate wasn't popularly elected, and presidential electors were appointed at the time by their states. And so within time, presidential electors became popularly elected, but originally that wasn't the case at all. So the one elected branch, Congress or the House of Representatives, was going to be elected in the same way that the states used to elect their most numerous branch, usually the lower house of their state legislature. The second thing the Constitution said was that the states could determine the times, places, and manner of electing members of the House of Representatives, and later after 1913, and senators was added to that clause, but that Congress had the power by law to make or alter such regulations. So our states set the rules for electing our federal representatives, but Congress can come and from time to time, by law, change that. So for example, Congress has created a single day on which we hold our general election for members of the senators or president, which we think of as election day. And the final thing that the Constitution said was that each state had to have a Republican form of government, and what that meant was very unclear. This clause has been litigated, and the courts have always said this is a political question. They haven't gotten involved and haven't really told us what that means. So beyond this, the right to vote comes from our state governments. And originally, when the Constitution was written, that right was extended to adult white male property owners. You had to own property to vote. Only adults could vote. only men could vote. African Americans could not vote. Women could not vote, though in my home state, New Jersey, actually women could vote from about 1790 to 1807, and then the legislature went and took that right away from women in New Jersey in 1807. There have been amendments, and when we give these talks, people say, what about all these constitutional amendments? What about the 15th Amendment or the 19th Amendment or the 24th Amendment or the 26th Amendment? Well, yes, there are constitutional amendments that we have passed, say the 15th Amendment in 1870, but these amendments have been written in what one might call the kind of negative sense. So they don't guarantee anyone the right to vote. What the 15th Amendment says is that the right to vote cannot be denied or abridged on the basis of race, color, or condition of previous servitude. The 19th Amendment to the US Constitution passed in 1920 says the right to vote can't be denied or abridged to anybody on the basis of their sex. The 24th Amendment says the right to vote can't be denied or abridged to anybody for failure to pay a tax, a poll tax. I'll explain in a minute how that worked. And the 26th Amendment says you can't discriminate on the basis of age in voting for anybody over the age of 18. It doesn't say that women have to have the right to vote, or people of a certain color have the right to vote. The way these amendments are interpreted is once the state gives that right to somebody, it can't be taken away. But there's no affirmative obligation on the part of the Constitution to give that right to someone in the first place. Now, historically, there are many groups of people in the United States who have been given the right to vote, and from whom that right to vote has been given or taken away, and it hasn't always been extended universally. So, for example, women had no right to vote. Some states did give women the right to vote, Wyoming, for example, New Jersey for a short period of time. And then after 1920, women have the right to vote because of the constitutional amendment all throughout the country. Native Americans have historically not had the right to vote. African Americans gained the right to vote, or at least African American males, in 1870 with the passage of the 15th Amendment. But for 90 years after that, effectively, many states in the South disenfranchised their African American populations through all kinds of tests and devices that they used. Paupers and the poor have been denied from voting. Minors and children have been denied from voting and still are to this very day. Felons in our country have been denied the right to vote, except in 2 states, Vermont and Maine, give incarcerated felons the right to vote, but no other state does. And then some states deny that right to vote from people who are on probation or parole. Migrants, in other words, those who have just moved to a state, have been denied the right to vote. In fact, most states had a 1 or 2 year durational residency requirement before people could vote, and that was only struck down in the 1970s. Foreigners, in other words, what the law calls aliens, or people who are citizens of other countries, aren't able to vote today in U.S. elections, but they have been able to vote in the past. And there are some states, especially as America was expanding, some states of the now we call it the Midwest, but then it was the Northwest, and it was Wisconsin and Minnesota, gave the right to vote to foreigners because they wanted resettlement to happen, and that was a way to entice people there. Just to wrap up this part of the presentation, I want to talk a little bit about methods that the states have used to take the right to vote or to control who votes. These are fairly uncontroversial. Most scholars in our field have sort of covered this area, but I'll give you a few examples of methods that states have used to control who can vote and who can't vote, and just to control their own electorates. Poll taxes. So for much of the 19th century and a large part of the 20th century, states forced people to pay a tax before they could vote. The tax was always very small, just $1 or $2. But when a person earned only $100 in a year, it was actually quite a large tax. And poll taxes were used to prevent certain people from voting who didn't pay tax, especially African Americans who couldn't pay a tax or couldn't afford to pay a tax were prevented from voting in many of the southern states. Secret ballots. So today we think of a secret ballot as being a good thing. In other words, you go into a polling booth and you pull the curtain behind you and you fill out that ballot and no one else is there. But in fact, when secret ballots were first used, they were used to disenfranchise voters, ironically enough, because literacy rates were very low at the time. And if you walked into a polling booth and there was a secret ballot and you couldn't take anybody with you, and nobody could tell you, the guy you want to vote for is in the box on the left, and you couldn't read the names, secret ballots were used to kind of disenfranchise voters who were illiterate, and literacy rates were only at about 50% for much of the 19th century. Literacy tests. So many states required voters to be literate, especially states of the South. And I always ask my students, how many of you think that you should be able to read before you could vote? And 50% of them or 70% of them raise their hand. And I'll often hand out a literacy test from 1872 from Alabama. And of course, the whole class flunks it because these tests were beyond reading. They were like trivia tests, who coins money in the United States, or if the president and the vice president should pass away, who's in the fourth or fifth in line of succession. They would ask these kind of questions that only very, very educated readers or readers who studied for the test could pass. So literacy tests were another method that was used. Many states in the South had something called grandfather clauses. So if your ancestors were able to vote, or your parents were able to vote, then voting was extended to you as well, and you didn't have to pay a poll tax or pass a literacy test. And all of these methods were used, especially after the passage of the 15th Amendment, to basically disenfranchise African American voters throughout much of the former Confederacy. White primaries. So the state of Texas, for example, ran primary elections, and whoever won the Democratic primary in Texas in the 1930s or 20s and 1940s would effectively be the senator or governor of the state, because it was a solidly Democratic state at the time. And the Democratic Party at the time had a rule that said only whites could run in our primaries, and in fact disenfranchising, again, African American voters. And these cases, we call them the white primary cases, came to the Supreme Court 4 or 5 times from the 1920s to the mid-1940s, and all of these white primaries were struck down on various grounds. Today, we also regulate voting, the states regulate voting through various methods. Voter registration, voter identification, early voting periods, absentee mail-in ballots, gerrymandering. Brad, do you want to say anything about any of these methods?
No, I mean, I am going to talk just a little bit about them, because some of the things, early voting, absentee voting, are some of the centers of controversy that we have now over voting. And so they're worth a little bit of time. I don't know where you were, Gene. Are you finished sort of with this kind of summary?
Well, let me
talk about these things.
Let me just summarize them very briefly. Voter registration in this country, voters are not automatically registered to vote, unlike in some other countries. And there's some controversies about this. A person has to register to vote and then vote, and those are 2 separate processes. And in most states, you have to register to vote 30 days, 21 days before you actually go vote. In much of Europe, people are automatically registered to vote. Some states allow same-day registration, and then in one state, I think North Dakota has no voter registration, or it happens at the same day. But most states have this separate period of voter registration and then voting. Those are 2 separate events that happen. And states have voter rolls, and so if somebody hasn't voted for a long time, states can actually take people off their voter rolls as well. Voter identification, this was an issue that was very hot 10 years ago, sort of less so now. Do you need an ID card in order to vote? Could you just say you are, Amanda Parker or Eugene Mazo, or do you have to show some kind of ID card? And if it's an ID, does it have to have a photo on it? Does it not have to have a photo on it? More recently, and Brad will get into this in a second, early voting. People used to vote just in person on the day of the election. Now states are moving to extend their voting periods early. Absentee and mail-in ballots. In 2016, 24% of Americans voted by mail. After the COVID pandemic, the number has ballooned and skyrocketed. It's way higher than 60% at this point. We'll talk about gerrymandering later. We're going to move to talking about voting controversies that, or not controversies, but issues that have happened in the last 2, 3, 4, 5 years, and especially since 2000. So I'll let Brad take it away.
Okay, well, sure. So as Gene noted, there's a long history of voting, and I wanted to comment a little bit on some of the current controversies that are out there. It seems like today in the United States, we have a tremendous back and forth about vote suppression and the idea of voter fraud. And I'll be quite upfront with the statement that I've always found pleases everyone and pleases no one, or to put it another way, half of the statement pleases half the crowd and half of the statement pleases the other half of the crowd. And that is that I believe that there's actually very little voting fraud in the United States, which is not to say there's no voting fraud, but there's not much compared to, for example, traditional U.S. history. And it's not as if the U.S. history has been more prone to voting fraud than most other countries. I mean, voting fraud has always been an issue. It's actually, we're running cleaner elections than almost ever before. At the same time, though, the idea of vote suppression, I think, is vastly overplayed. I think that the plain and simple fact that it has never been more convenient to vote in the United States. And as Gene noted, if you look at the historical methods that have limited the franchise, most of those are gone. You don't have poll taxes, property taxes, literacy tests, and so on. And I think what we have that then begins to fill this void is partly a partisan argument, because almost any change one makes to election systems can have partisan effects, at least in the short term. Often in the long term, it's very hard to know who benefits, but in the short term, at least, it's often quite clear which party may benefit from a change in the law. And so this gets a lot of partisan juices flowing. But there's really, I think, a battle between two views of what voting is and what it's intended to be. On the one side is the view that the purpose of voting really is a sort of direct popular command or pull for what policy ought to be, and that the goal of voting is essentially to take political equals, in which we are almost all then viewed as political equals now. In other words, there's no longer, you no longer have to own property, you no longer can't vote if you're African American or something like that, right? So that kind of stuff's gone. A community of equals, and the idea is to amass enough votes to get a majority, and then you have a right to sort of enact your policies. And that's a very heavy emphasis on the democratic side. But we live in what's often called a democratic republic, small d, small r. And the Republican side to that is one that places simply less emphasis on voting as a means to carry out sort of the popular will, and rather views voting as one of many, and a very important element, but one of many elements in the American fabric that protects liberty and assures stable government. So voting is a way in which we assure peaceful changeover. It's a way in which we assure at least some responsiveness to the citizenry, but at the same time, other elements of our constitutional system fill that role, or fill some of those roles, different roles. And those include separation of powers. Those include a federal government of enumerated powers. Those may include bicameralism. Those include having a Bill of Rights at all. So there's a number of other checks that come into play. Again, voting is very popular, but voting is just one thing among many. And one of the things that we would want to do is then use mechanisms to sort of improve voting. That is, to make people better voters. If you look at some of the things that were used historically to limit the right to vote, many of them have at least a solid rationale that can be given for them, and at least in some cases probably was related to the reason why these things were imposed. Even today, you'll find a lot of people who say, look, people shouldn't vote if they don't pay taxes. They should have some kind of skin in the game. I think the idea that you should be literate to vote is one that many people would strongly agree with, that it's very hard if you're not literate to perhaps cast an informed ballot, so on. Now, these things can be contested, whether we should have that kind of restriction, or again, whether the idea should be all of us are at least political equals and everyone gets to vote. But at least there's a solid argument for those kinds of restrictions. And what tended to happen, however, that discredited most of those restrictions over time was that they were in fact used to limit voting by particular classes of people rather than simply to try to elevate voting as the sort of neutral reason for their being would have. Gene noted one thing that limited voting as grandfather clauses. Grandfather clauses didn't really limit voting for anybody. What they did was they actually exposed the rot at the use of the system. That is, okay, we want a system, speaking in the 19th or early 20th century South, we want a system in which we're not going to let blacks vote. And we want whites to vote. So we'll have a literacy test that will be almost impossible to pass. And then we'll make sure that any whites who can't pass it can still vote. How can we do that? We'll have a grandfather clause. If their grandfather was eligible to vote and their grandfather was born before the Civil War, right, then these people are able to vote and keep voting over time. So grandfather clauses were less a restriction per se on voting than something that showed rot that was going on in the system. Anyway, to show how things have changed, if you've been around a while, if you're getting to be an oldster like me, you recall that early voting is something entirely new. And in fact, prior to the 1970s, when a couple states began very limited experimentations with early voting, there was no early voting. Generally speaking, there was no early voting prior to the mid 1990s, in which you could go in and just vote in person, and whereas now many states have 6 or 8 weeks of early voting. In person or absentee voting, I should say, by mail was generally frowned upon. The first state to have no fault absentee voting by mail was California, and that was not until 1980. The idea was that the norm was that you would go vote at the polls on election day. And there are reasons why, again, a lot of people are uncomfortable with early voting and mail voting. I think the rate of fraud, for example, in absentee voting is very low. I don't think there's a very high rate of fraud at all. On the other hand, it would have been up until probably 2 years ago when I think partisan politics took over, it would have been entirely uncontroversial to say in a political science conference, there's more fraud with absentee voting. That was just, that would be like saying the sun rises in the east and sets in the west. Similarly, absent or mail voting, absentee voting by mail is a little bit more likely to be discarded. Not many votes are discarded, but a few are, and so it's more likely to happen. The bottom line, to me, that's of greatest interest is we have some crisis of confidence in voting today. Can people count on the results? And this has been obviously a big source of issue. And one of the things we see is that one of the few things that has a positive statistical correlation to people's confidence in election results is whether they voted in person at the polls. That's one of the things that gives people confidence. And I think it's maybe they see the system going on, they see it works. The other idea would be that having people vote in person at the polls gives people a sense of what we're doing is governing ourselves as Americans. We come together, and it reminds us that we shouldn't really hate people who have different political views. We're all engaged in this big process. We stand in line next to one another, thinking about our voting with a little bit of time to be kind of quiet. So that's the kind of battle we have. I want to go, Gene, if we can get through a couple slides that show very quickly how much early voting there is. I don't know if you move some through.
You want to see that one, or do you want to go the other way?
We can skip through this one, go on down. The next one. This shows 9 states, by the way, and if you're good at maps, so I know at least one person in the audience is, you'll know what 9 states these are. These 9 states now do almost exclusively mail voting. It's that is the norm. But let's go on down and talk a little bit about the vote suppression argument that's sometimes made. I just want to run through some slides to give some perspective to this argument. So if we can go on to the next one here.
By the way, these 9 states, they all do universal vote by mail voting, except for Montana that does it in 32 out of 34 counties. So everybody gets a ballot and you mail it back. and there is no in-person polling places, that there are drop boxes. This is a huge change that has happened in at least
Yeah,
some
and you would not have seen this. This is just, I don't want to dwell on these maps, but this is just a quick map of Europe, as you can see. The countries in green do not require photo ID, but have announced that they're going to start requiring photo ID. The light blue country, that's Denmark, requires photo ID if requested. All of the other countries you can see require photo identification in Europe. Now, there are some differences. For example, most of these countries have a uniform national identity card, which Americans have always fought against having imposed. And so it's not quite apples to apples, but it still shows the idea of photo ID is not considered a radical one elsewhere in the country or in the world. If we go on to the next slide here, there's three more. This one shows which countries allow postal voting, that is absentee voting by mail. Again, countries in green allow absentee voting. Countries in the light green allow it in some circumstances, what we might call excused absentee voting. The orange countries don't allow it. And again, we don't need to spend a lot of time on it, but you can see that most of the countries, including France, Italy, for example, the Scandinavian countries, don't have postal voting. Going on to the next one, we see basically the same kind of thing. This is early voting. And again, you see that most countries do not have early voting. Here, the Scandinavian countries do have extensive early voting, but they don't have the absentee voting. And I think we've got one more slide in this little group. And this is what is called proxy voting in Europe, or what is sometimes derogatorily called here ballot harvesting, where someone else can return your ballot for you, an early ballot. And you'll see again that, in countries that I think we would view as enlightened democracies, Finland, Germany, Italy, Spain, and so on, this practice is not allowed at all, and in others is constrained in different ways. So I just flashed those up to add a touch of perspective to what has become a very heated argument in the United States. And again, my perspective would just be to say, I think everybody needs to relax and recognize that, actually elections in the United States are really run quite well. And there's probably never been easier to vote in the United States. And at the same time, it's very hard to make a case that elections are being lost due to fraud. I mean, some are. You can find a few, and you can always find some problems at the polling place. We have over 10,000 polling places in the country that will be open on Tuesday. There will be one somewhere where a water main will break in the building, or the voting machines will break down or fail, or the officials will have simply vastly underestimated the number of machines needed, perhaps in a new polling place. And so then you'll hear stories of long lines and so on. But as a general rule, when you think about the massive undertaking we're about to take in a week, you realize that our elections actually are extremely well run and quite smooth. The average wait time, and both the median and the average in the United States, is a little over 10 minutes that people have to wait to vote. So the process really works pretty well. Gene, I don't know if you want to add anything to that. It seems almost like a touch of rah-rah there at the end, but I really do think we don't sometimes get enough credit for doing actually a pretty good job in running elections.
I would add a few more things. American elections, most people don't kind of think through this or realize this, or maybe most people have, are extremely decentralized compared to almost every other country. So whereas in some of these European countries that you see on some of these maps, there's a central election authority, we have almost no such thing in the United States. And we have not only 51, I would say, including the District of Columbia, 51 different electoral systems or voting, authorities. We have thousands of them because each county runs elections in a very different way. The ballots look different from county to county. You might know this in Ohio if you've lived in more than one county. The voting machines are different from county to county. The county officials responsible are sometimes do different things within a state. And we have kind of a system where Brad you had a good way of describing this. You said this to me the other day. It's a national. You had a good phrase for this.
Well, we don't really have it. I served, as some of you may know, I don't think Lucy mentioned it in the intros, but I served as the chairman of the Federal Election Commission from in 2000 to 2005. And I always just talk about what a grandiose title that was, because we don't really have federal elections. What we have are state elections for federal office. And you note that polls close at different times of day, different hours. Gene mentioned some states allow felons to vote. Some states don't allow them to vote. Some allow them to vote, but not if they're only when they're on, parole. There's all kinds of different rules that exist around the country. And people vote on different types of machines, which are often adopted, different ways of voting for local conditions. So it is a very decentralized process, and I would be very different to go to a more centralized process. I've been in countries as an observer where the process is much more centralized, and there are pluses and minuses to it, but we should recognize that it would be a big change.
Okay.
Let's go on and talk about gerrymandering, because we're starting to get a little bit behind where we want to be. So gerrymandering, I'm just want to lay out a couple very basic descriptions. Gerrymandering, I think most people know what it is, but lately the term gets thrown around an awful lot. Gerrymandering is basically the process of drawing congressional districts or legislative districts of any type, state legislatures, in order to favor a political party, as opposed to drawing them for what are viewed as sort of, quote, traditional criteria, such as compactness, keeping political units together, cities and counties, keeping geographical regions or other communities of interest together. It's kind of funny, by the way, if I can digress for just a minute, the term draws its name from Elbridge Gerry, or he pronounced it, I believe, Gary, but we normally call it gerrymandering. Elbridge Gerry, for those who don't know, was a member of the Continental Congress, and as such, he signed the Declaration of Independence. He was also signatory of the Articles of Confederation that Gene mentioned earlier. And then at the he was at the Constitutional Convention. He was one of the most active speakers at the Constitutional Convention, was quite influential, but he eventually did not sign the Constitution, kept him from being one of just 3 or 4 people who would have signed all 3 of those documents, the Declaration, the Articles, and the Constitution, because it didn't have a Bill of Rights, and he was very upset by that. He went back to Massachusetts, where he was then elected to the Congress. So he goes back to Congress, even though he voted against the Constitution. And there he lobbied hard for the Bill of Rights, and probably more than anyone is responsible for 2 parts of the Bill of Rights: the 4th Amendment against unreasonable search and seizure, and the part of the First Amendment guaranteeing the right to assemble. He then goes on, he serves as governor of Massachusetts, which is where gerrymandering comes from. When he was governor, the state legislature drew up these really weird districts to try to ensure one-party control of the Democrat-Republican Party, as it was called. And Governor Gerry signed the bill. That's the governor. That's all he did. He just signed the bill. And then he served as vice president of the United States. He was the 5th vice president of the United States. So here's a man who has all these accomplishments, and all most people know of him at all, if anything, is he's associated with the term gerrymandering, which he had almost nothing to do with. But that's just a little digression that I always find kind of interesting. Before we turn to what's been going on in Ohio, and I think there'll be at least some general awareness of that. Gene, what are your thoughts generally? Is how big a problem do you think gerrymandering is?
I think it depends on the state. In all states, there's a little bit of a skew. First of all, gerrymandering is practiced by both parties. So Republicans gerrymander and Democrats gerrymander. Republicans do it in Wisconsin, and then Democrats do it in Maryland, for example, or in Illinois, or in Massachusetts. And the way the system works is, you try to pack people that are like-minded in a small number of districts so that they elect fewer representatives that are like them, or you try to crack districts. You try to take a district that has some population, and then you try to crack it and put those people in different districts of a certain political affiliation to make it harder for them to elect the representatives of their choice. I mean, the problem is, it is the way our country works. And when scholars look at this, just to answer Brad's question, what I think of this, because this issue has come before the Supreme Court now several times. And of course, we had a case from 2 years ago called Rucho versus Common Cause, where Chief Justice Roberts said, gerrymandering is a problem in this country, or maybe not a problem, or a tradition in this country, but it's not something for the courts to resolve. The problem, or in quotes problem, is that there isn't a baseline of what a fair district looks like in the first place. And so, a lot of people look at a map and they say, well, this map is totally unfair. And then you ask them, well, what does a fair map look like? And most people can't really answer the question for you, because you have to have some knowledge of what a fair map is, or some criteria to draw the map in the first place. So that's the problem with gerrymandering, is we've been doing it for so long, we don't even know what a fair map is. And scholars and people in our field have invented all kinds of formulas to try to determine, is this fair, or is this not fair? And the problem, or not the problem, but the reality is the courts have never adopted any of those. To answer Brad's question, go ahead. Yeah.
Oh, I should say, yeah, I think one of the things is, for example, you look at the little squares that are up on the board there. You think about it, you could divide districts that would be nice. They would look very geometrically sound and everything, but you could draw them horizontally or you could draw them vertically, right? And that would make a huge difference in what kind of districts you got. So one of the big problems with avoiding gerrymandering is that the process of geographic districting has some inherent political calls you have to make. What groups of people should be put together? And so, for example, for many years, I lived in Columbus back in the 1990s. And to me, I would think about gerrymandering, and I would say, who do I have more in common with? Should I be put in a district that includes all the citizens of Columbus, including a lot of people with whom I have very little in common on the South Side? They have very little in common with me. Or should I be put in a district but we have certain things in common, interests of Columbus that we were concerned about being represented in Congress. On the other hand, maybe I should be put from my home on north side of Columbus in with people from Worthington and other suburbs to the north. Maybe I have more in common with them. And in fact, I'm geographically closer to them. So, you have to make that call. Which kind of community of interest are we going to keep together, and which one are we going to split? And once you start doing that, it becomes an inherently political process. And it's very, very hard to kind of police what most people intuitively think is an unfair practice of trying to make sure that members of one party get most of the seats in the legislature.
Yeah, I mean, we have cases where, in Wisconsin, for example, I'll give you the Wisconsin example, where I think gerrymandering was unfair. The Republicans in Wisconsin got a smidgen under 50% of the vote in a statewide vote, but took 63 to 66% of the seats in the state legislature. That comes out as a result of gerrymandering. In Maryland, the legislature redrew districts. There were 6 Democrats in Congress and 2 Republicans, and they took a district just north of Montgomery County that took in the western part of Maryland, and then grabbed pieces of Montgomery County, right, pieces of Bethesda into that district, and all of a sudden, the Republican legislator was no more. He was replaced by a Democrat. So this is a practice that has been going on in our country for 200 years. It has no end as I see it. And today the federal courts have said we're not going to get involved in this. And so the litigation all happens at the state level now. And each state draws districts in different ways.
So
go ahead.
I just want to cut in, Gene, to move us along, to just note, the point that the Supreme Court's made is, look, we can't determine these districts either. It's a political question, and I think that's the issue they have. And so, as Gene says, it's gone to the state. So a lot of people have seen what's been going on in Ohio. In Ohio, basically, you have a redistricting commission that is set up. It consists of one member from the majority party of each the House and Senate, one member from the minority parties. You've got at least 2 Democrats and 2 Republicans to start. And then there's delegates appointed from 3 statewide officers, the governor, the auditor, and the secretary of state. So if one party controls 2 of those 3 offices, they'll control the redistricting commission and tend to draw districts that favor that particular party. In 2015, Ohio adopted a constitutional amendment that required that the proportion of districts whose voters, based on statewide, state and federal partisan general election results during the past 10 years, based on that, the proportion of districts should favor each political party shall correspond closely to the statewide preferences of voters of Ohio. So in other words, the basic idea was if you had 55% of Ohio voters voting Republican, then they should have 55% of the seats in the state legislature, roughly speaking. But it's very hard to do that because if you kind of catch that language, over the last 10 years, partisan, federal, and state election results what do we do? We have elections such as, for example, some residents will remember when John Kasich just pounded some Democrat who have long since forgotten in the re-election campaign of 2014. And that will kind of skew those results. What do you do with races, for example, urban districts in Cleveland, where the Republicans don't even field a candidate because they don't really have a chance of winning? So the percentage of Republicans drops to 0 in those races, skewing the results. It's very hard to come up with something like that really is going to work. And then, of course, this overlooks the fact that voters are not automatrons. I mean, we do change our opinions. People will change over time. Many Republicans would not vote for Donald Trump, and there are Democrats who won't vote for certain Democratic candidates. There are independent voters in there. And so the system is very, very unusual. It's made even more unusual because the law actually says that the commission shall attempt to draw lines that meet this criteria. It doesn't say that it will. It says it shall attempt to draw lines that meet this criteria. And what happens if it doesn't? If it doesn't, the redistricting scheme is kept in place for only 4 years. And what determines if it doesn't, I should say, is if the plan doesn't get at least 2 votes from members of the commission on each party, then it's only in place for 4 years. And then you have a redistricting again, when presumably those offices may have changed hands, those 3 key offices of governor, auditor, and secretary of state, allowing the other party to gain a majority and impose its district lines for 6 years. So it's a very odd provision. It's complicated by the fact that the Ohio Supreme Court has clearly authority to review redistricting plans for their compliance with the Constitution, but it clearly does not have the authority to impose a plan in Ohio if it doesn't think any of the plans there are constitutional. And further, any plan adopted in Ohio has to be approved by the redistricting commission. So you've got these kind of conflicting provisions, and that led this summer to the commission adopting it. Again, it had a 5-2 Republican majority. It adopted a series of maps on straight party line votes. And each time, 4 different times, the Ohio Supreme Court said that they didn't think the vote met the constitutional criterion of not being drawn to favor one party or another. Finally, voters went to federal court, and they said, well, since we don't have districts, we're being deprived of our right to vote, and this is a federal cause of action. The federal court stepped in and eventually chose a map chose one of the Republican maps, and that's what we'll be using in this election. But it will only be in place for 2 elections, and then we'll see what's happened. So it certainly is a big mess in Ohio. But on the other hand, I'm not sure that the map that people will look at is any more gerrymandered, again, than the maps in many states or maps that Ohioans have voted for in the past. It just emphasizes, I think, the difficulty of getting a handle on this issue of gerrymandering. You can't really force people to pass a legislative plan they don't want to pass. And if we don't let the Supreme Court of Ohio impose a plan, and for various reasons, people don't want the Supreme Court just imposing a plan, you're likely to have these kinds of impasses. Gene, we're at 7:45 now. Do we want to do a quick run through of these 2 primary cases? Or
yeah, why don't we? And then we'll just stay around for as long as people have questions. By the way, let me just to wrap up the gerrymandering thing. There are states, and this is controversial, Arizona, California, Michigan, Colorado, that have independent redistricting commissions. And so, for example, in Arizona, the people of Arizona, through a ballot initiative, through direct democracy, very controversially, adopted a commission to circumvent the legislature. And that commission in California has something similar, draws the districts. And how people are chosen for that commission is a fairly complicated formula. In Colorado, for example, the Colorado Supreme Court oversees that independent commission. But you try to get neutral people to draw districts. Of course, the legislators don't like this. And there's been lots of litigation around this. But there are states that have independent redistricting commissions. In my state, New Jersey, we have a bipartisan commission that has to choose a 13th member. And it's always a very, very contentious and difficult thing. So The process works very differently in different states.
And we should add on there that whether these independent commissions work at all is a very mixed question. Many people said, for example, California is a state that has one, and many people say that their districts are more gerrymandered than before they had an independent commission. What happens is, particularly when you try to get a bunch of people, most of these are set up in ways to try to make sure that nobody on the commission has any political experience. And what happens when you get that is you have a bunch of people who can be manipulated by sort of the consultants and the people who come in on the parties, and the parties, provide them with data at these public hearings. So it's not that they're necessarily a bad idea. I don't oppose states that want to do it, but I think it's that they have not delivered on the promise, at least not yet.
Right. And to give you a very simple example, should we draw districts that are competitive, where you don't know who's going to win, or should we draw districts that are non-competitive, where we protect incumbents? I mean, that question is very difficult to answer, and these commissions, they have to start with some kind of criteria, and they're not politicians drawing these districts. Okay, Brad and I are going to take you through two cases that are currently before the Supreme Court. They are the two hot cases that in our field, in election law, everybody's watching. One of these cases is going to be argued on December 7th, I think. So I'll take you through one of the cases, and Brad will take you through the other one. The first case that I want to take you through, and it naturally rises out of the redistricting questions, is a case called Merrill versus Milligan. It's a case that arose out of the state of Alabama. To understand the background, I'll just explain it this way. In 1965, Congress adopted a law called the Voting Rights Act. This was adopted not long after the events on the Pettus Bridge in Alabama, where John Lewis was crossing the bridge and African Americans were trying to vote. And the Voting Rights Act has been a very controversial thing in this country. Some people call it the jewel of the American civil rights laws. Other people think the Voting Rights Act is outdated and there should be a sunset put on it. The Voting Rights Act had two sections. That they had more than two sections, but there's two sections that are major sections of it. One was called Section 5. And what Section 5 of the Voting Rights Act did was it created a bunch of jurisdictions. They were called covered jurisdictions. And here's a map of them as they existed about a dozen years ago or 10 years ago. It created a bunch of jurisdictions called covered jurisdictions. And these jurisdictions were jurisdictions where the percentage of people who were registered to vote in 1964, then later the formula was the formula was rejiggered in 1972, was less than 50%. And these jurisdictions used some kind of test or device for voting, that they had literacy tests or poll taxes or so forth. And these jurisdictions, as you can see, most of them are states in the South, though Arizona was a covered jurisdiction. Pieces of New Hampshire were, 40 out of 100 counties in North Carolina were, parts of Virginia were, Alaska was. These jurisdictions could not make any changes to their voting procedures without asking permission. The permission had to come from either the U.S. Attorney General's office or from the federal district court in the District of Columbia. And so the Voting Rights Act was made because these states had been discriminating against voters, and basically they didn't have to go open up, polling places for African American voters or minority voters. But if the legislature wanted to take a polling place and move it 2 blocks away, you couldn't do that without going to ask for permission. And so basically we got to a standstill. A case in 2013 came before the Supreme Court called Shelby County versus Holder, where the Supreme Court basically said that this coverage formula that is used is really outdated, and struck down this coverage formula of which states are covered, and said to Congress, hey, Congress, you've got to update this coverage formula. You're treating these states differently than you're treating all other states, and you're basing it on a formula that's 50 years old. And of course, in Congress, the votes aren't there to come up with a new formula because of some of the polarization that we have. In other words, the House, controlled by Democrats, is able to come up with a new formula, but of course it gets nowhere in the Senate. And so Section 5 of the Voting Rights Act, in effect for the last decade, has been inoperable. As soon as Section 5 was struck down, these states here that are on this slide within just a few weeks, began passing new voting laws to regulate voting in different ways. Some of them implemented voter ID laws. Some of them made those voter ID laws strict. In other words, you had to have a voter ID to vote. You had to present a picture ID to vote. Some of them had, photo ID laws. Some of them you needed an ID, but without a photo. They did all kinds of different things. But all of these states here on this slide couldn't make some of these things happen. And as soon as the coverage formula was struck down in Section 5 of the Voting Rights Act, these states and other states began changing their voting rules for better or worse. The fact is that they did begin changing them. There was another section of the Voting Rights Act that was very important called Section 2. And Section 2 of the Voting Rights Act did not apply only to those states that were deemed to be covered jurisdictions. It applied to the whole country. Originally, Section 2 mirrored the 15th Amendment, and it prevented discrimination based on race in voting. And Section 2 was not as important as Section 5 originally. It became much more important over time. But one thing that we had in Section 2 is the way that Section 2 applies was litigated. It was fairly controversial. And in 1982, Congress went and amended Section 2. And then in 1986, we had a case decided by the Supreme Court, which gave us a test. It's called the Jingles test. The case is called Thornburg versus Jingles, which told us when jurisdictions had to create what we call majority-minority districts. I mean, these are districts that are able, where the people who live in that district are able to elect a representative of their choice. So we have districts today in the United States that elect a Black congressman or a Latino congressman or an Asian and Pacific Islander congressman, etc. And the reason these districts, we have more of them, is because Section 2, as interpreted by Jingles, requires this to happen. Well, this past year, Alabama redistricted. So we redistrict every 10th year after the census comes out. And Alabama drew new districts. And Alabama has 7 congressional districts, of which one is a majority-minority district. In other words, it elects a Black Democrat, and all the other districts elect a white Republican. And these civil rights groups, rightly or wrongly, sued. And following precedent, the courts, the federal district courts in Alabama, told the state that under the Voting Rights Act, under Section 2, Alabama had to create another Black district, so that the state would have 2 Black districts and then 5 just regular districts, congressional districts. Because Alabama's population is about 27% African American, and if those folks happen to be concentrated in a certain area, and they can show, this is the Supreme Court test, and they could show that they're politically cohesive and that white voters vote against them as a block. In other words, they vote as a block, and then white voters it's called racially polarized voting. White voters vote in order to defeat Black candidates, as opposed to just picking candidates that they want, irrespective of race. Another majority-minority district has to be created. Well, this case now has come before the Supreme Court. This case out of Alabama. And it's a very contentious case. No one knows how it's going to come out, but most people think, most experts in our field think, that the Supreme Court is going to at least cabin or rewrite the test. At least that's my opinion for Section 2 of the Voting Rights Act. And we might have a different test or slightly different measures of when we have to create these majority-minority districts, which are very controversial because there are districts, that are designed for our minority populations, especially if they're politically cohesive and geographically cohesive, to elect a representative of their choice, not only to Congress, but also to their state legislatures. That is what this case is about, and this case is currently before the Supreme Court. There's another very important case before the Supreme Court that Brad will talk about, called Moore versus Harper, that concerns something called the Independent State Legislature Doctrine. Brad?
Okay, well, I'm going to try to keep this extremely short so we can get questions in. Basically, there's an argument. The question is, the Constitution at 2 different points in Article 1, Section 4, and in Article 2 talks about the state legislature having responsibilities. In Article 1, it's for prescribing the manner of holding elections. In Article 4, it's for the manner of choosing electoral voters. And the question really before the court is, when it says the legislature, some people argue that means literally just the legislature. So there would be no gubernatorial veto. There would be no judicial review. It's the legislature. The historic traditional view, which I think will win the day at the Supreme Court, is that the legislature means the legislature as it operates within the normal structures of the state constitution. That is, with the governor's veto in most states that can be overridden in some way, and with some level of judicial review. Just because I want to get to questions, and in the interest of time, I'm not going to say more about that. If people have questions, I'd be happy to go into more detail into that independent state legislature doctrine. The concern that some have is that it's gotten tied up, as everything does today, in partisan politics. And some people said, well, this would allow a state legislature to just appoint presidential electors even after the state's presidential vote had gone the other way. So the perception that, for example, this was actually an argument used by some of the in the Trump controversy, some of the Trump supporters said, well, even though our state, according to the canvass, voted for Biden, the state legislature has the authority to send other electors. I think that's not true for a very simple reason. The Constitution also gives Congress the right to override these regulations of the states. And Congress has set a date on which states have to choose their presidential electors. That's the November 8th this year, that election day. And so that a state that was unhappy with the result that day could not go back and change it later because they would have missed the deadline. They have to do it on the day Congress prescribes. It's a complicated issue. I think that there's probably much less at stake there in a way than meets the eye. But if the court were to rule that state legislatures could do districting without any judicial oversight and without any gubernatorial role, I think we'd find it somewhat chaotic, particularly when legislatures might divide in certain ways, not be able to come to resolutions. For example, Minnesota has a Democratic House and a Republican Senate, or maybe it's the other way around. Alaska has a Democratic Senate, a Republican House. So these things can get confused in that kind of way. I'm just going to leave that complicated issue there and suggest that we move on to see if folks have any questions that we can address.
Yeah, and the other thing I would just add is actually until the 1830s, there were many states that actually, the state legislatures did actually appoint their presidential electors, and that changed over time. So today, in every single state, there's a law that says the presidential electors shall go to the person who wins the majority of the vote in that state, except for two states, which is Nebraska and Maine. They divide their electors by congressional district. So,
yeah, but the point is they're all using popular elections, and they're doing that because that's the process the legislature chose. And like I say, in my view, I don't see how the legislature, if that process yields a result it doesn't like, could go back and change it, because the federal law is very clear. You have to choose them on that first Tuesday after the first Monday, this year, November 8th. So the legislature can't come back into session on November 10th and say, oh, we don't like the results in our state. We think they were too fraudulent. We're going to change the result. They've missed the date.
Okay, so that concludes our presentation. We're happy to answer any questions. Election law is fairly technical, but we're happy to answer any questions or general questions that folks might have.
Yeah, feel free. We are a small group tonight, so feel free to unmute and ask your question if you like, or if you feel more comfortable, you could put it into the chat.
There's a question in the chat. Anybody have a question? Please ask.
Maybe I should go into the legislative, independent legislature doctrine.
I guess I can ask a question about the maps redistricting in terms of the no baseline. I guess with computer programs and whatnot, things are very different now than the way they used to be in terms of our ability to create unfair districts, I guess. So so it's really hard. So do we not do it just because it's really hard? And, you could think of a baseline schools in the South were always segregated, right? So we had no baseline of what a desegregated school looked like. So therefore, so I guess I want to push back on that a little bit. Maybe that's not the best analogy, but there are lots of things for which we don't have a baseline, whether you think about internet technology, regulations along those lines. So I guess, at some point it's problematic. And I think we can do better, and it won't be perfect, but I don't know. What are your thoughts on that?
Well, I'll go ahead first. I mean, part of the problem is, again, even if you say certain criteria are a baseline, it won't necessarily resolve how you want to draw the districts. For example, let's suppose you say our baseline is we want compact districts. We can draw compact districts in a lot of different ways that would be sort of equally compact, putting different groups together. Most states, in fact, have a requirement that districts be compact. But again, it's something that's not really amenable to judicial enforcement to decide how compact they have to be. You could do something like say, districts have to be, in Ohio, we try to say it should be roughly proportional to voters. Like I say, I think that raised some problems. I mean, voters shift, they change their minds, they change their positions over a decade. But leaving that aside, ultimately, you're talking about some type of proportional representation. And I'm not sure that, if you want proportional representation, we should probably go to proportional representation. The whole idea of geographic representation, which is what we have, what the United Kingdom has, what Australia has, and so on, what Canada has, is where you're elected from a district, is to make sure that geographic regions are represented. If you do that, know that first you have a certain natural gerrymander, right? You're not going to get a competitive district up in Cleveland. That's going to be a Democratic district. You're not going to get a competitive district in parts of Northwest Ohio. It's going to be a Republican district, right? No matter how you want to draw it up. So then the question becomes, what are we trying to get? Do we want competitive districts, as Gene said? If we want competitive districts, we might have to gerrymander, that is, draw really weird districts to make them competitive. There's advantages to competitive districts, but there's disadvantages too. Think about it. If you have a competitive district, the day after the election, 49% of the people wake up unhappy. If you have a non-competitive district that somebody wins with 68% of the vote, then the day after the election, only 32% of the people wake up unhappy. And if you're concerned about people having confidence in election results, one of the few things we know really affects confidence, it's whether your candidate won. So gerrymandering, may have even a positive effect in that limited kind of way in that situation. So I think that there are things we can try to do. I think that it doesn't hurt for states to try to include more objective criteria for their map makers to use. I'm not averse to states trying to come up with independent commissions. But when Gene says there's no baseline, I think what we can really say is that there's no agreed upon theory as to what would be a good district. The only one that I think you could really toss out would be something along the lines of proportional representation, but people don't necessarily agree that proportional representation is the good theory. So the frustration in your question, I think, is very real, and it's shared across the country. And I hate to be the provider of doom. I'm just skeptical that it can be met. But I do agree with you. I don't think we should give up. I don't think we should just say, well, the heck with it. We should just allow it to go. And I could tie it into even a bigger issue where I think we need more people in office to take care to enforce the laws faithfully and truly. One thing almost everybody in office, even poll workers and lawyers and stuff, take oaths to uphold the Constitution. And I think sometimes not enough people take that seriously. Instead of trying to live up to the spirit of the oath, they try to look for what's the least I can do that might not violate the technical letter of drawing the districts or whatever it is. So I guess the bottom line though for me is just to say it's going to be a long ongoing battle, and because really in the end drawing districts has an inherently political element to it.
Yep. So I'm going to disagree with Brad, and that's okay because we're friends, that we're from slightly opposite sides of the aisle. I think that you can battle gerrymandering. and that there are tests that have been proposed by people in our scholarly community, especially scholars have proposed lots of different tests. So for proportional representation, in Europe, most countries in Europe use a system where they have multi-member districts, right? The district elects, 15 representatives. And if the Greens get 5%, then the 5% of the people from that district, going to whatever, the Bundestag, are from that party. Congress has always said, that's un-American, that we don't want a system of proportional representation over and over. But for example, in a lot of this redistricting litigation that happened, and people kept trying to get this into the federal courts until this Rucho case came down 2 years ago, there were lots of tests that were proposed about what would make districting fair or unfair, mathematical tests. So for example, there's a test called symmetry. In other words, if Democrats win, 60% of the vote, but have 66% of the seats, that's perfectly fair if in the next election, Republicans win 60% of the vote, but get 66% of the seats. But the system in Wisconsin, where Republicans are winning 48 or 49% of the vote, but have 66% of the seats, strikes me as being terribly unfair. That strikes me as being anti-democratic. And there are tests that we have, mathematical formulas and tests. So there's a fancy one called the efficiency gap, which talks about the wasted votes statewide that you have, that a bunch of colleagues of ours in election law invented. The problem is the courts have never adopted these tests, right? When we litigate this, the federal courts have said, I'm not really sure. What do we mean by the federal courts? We had a case in 2004 that came before the Supreme Court. And in that case, Justice Scalia and 4 of his colleagues said, this issue is a non-justiciable issue. It's not an issue for the courts. And there is no test that you could possibly adopt. The Justice Kennedy's in the middle said, no, this is a justiciable issue. The court should resolve this, but I don't know what the test should be, he said. And I don't know if we'll ever figure out a test of what makes gerrymandering fair or unfair in my lifetime, he said. And the 4 liberals on the court at the time went and decided and it devised 3 different tests among the 4 of them. And then Justice Kennedy said, I told you there's no test, you guys can't even agree. So what we had was 5 votes to say that gerrymandering is an issue that the courts can resolve, but there was no majority for any test whatsoever. And we have kept trying to propose tests, lots of mathematical tests that would make, some kinds of gerrymandered districts unfair because they're wasting too many votes of Republicans or Democrats or whatever it is. And the courts have rejected them. And the tests have become simpler and simpler to get judges to sign on, but the courts have said, no, we don't want to wade into this. And so I think that there are ways to lessen gerrymandering, but the question is, who's going to make that decision at the end of the day? We don't have somebody to make that decision. The federal courts have said this is a decision for the states to make, and have pushed that away from themselves. And so the problem is there's nobody to make such a decision. It's not that we don't have the tests, it's that we have too many tests and we can't agree on one of them, because there is no, as I said before, and on this point Brad and I agree perfectly well, which district is fair? How do we decide in the very beginning what a fair district looks like? Does it have to be square? Or does it have to have an equal number of Democrats and Republicans? Or does it have to be very, very competitive so that the election is won by 1 vote or 2 votes or 5 votes? Or should it have safe seats? Should the district be connected in different ways where each parts of the district touch each other? Can you have a mountain range or a lake in the middle of a district? These questions are answered differently by different states, and we just keep arguing about this issue. But I think Americans, I would say for myself, understand that there's something wrong with this process, that there's something, I don't know, weird about it, that it shouldn't be this way, but we just don't know what to do about it. And the courts aren't helping us. They're not going to help us going forward. By the way, in New York, the Democrats gerrymandered in such a way, by the way, I'm a Democrat, and the Democrats gerrymandered in such a way as to basically make it so that there would only be 3 Republican members of Congress, and the other 24 members of Congress would be Democrats. And the Republicans sued, and a New York judge went and got a special master to redraw these districts, who I actually know fairly well. He's a guy who's very capable of doing this, and he, drew districts. So now you know, instead of having a safe liberal Democrat on the west side of Manhattan and a safe liberal Democrat on the east side of Manhattan, he drew the district this way across the Manhattan. And if you've been reading the New York Times, you know, Carol Maloney and Jerry Nadler went up against each other, people who have been colleagues for 30 years. Is that fair or unfair? I don't know how to answer that question. But the district is, the shape of the district is going to determine who comes out to run in the first place, right? What we're seeing in this election actually is a lot of these races that we thought would be uncompetitive have become way more competitive because districts were drawn to be more competitive. So in New York, seats that we thought of as safe are not as safe anymore. Seats that we thought were safe for Republicans are not as safe anymore. Maybe we're better off this way, but maybe not, because now people are spending much more money, you know, to hit voters over the head, and more funding is being raised. But at the end of the day, you know, my view is the greater problem in this country is polarization, that people of different sides are drifting apart and can't speak to one another. But that's a different issue that we could talk about.
There is, well, a follow-up comment by
Sure.
Kumler, sort of regarding what you were just speaking of. The goal would be competitive districts. 49% and 51% is great because a person has to perform and is accountable. They cannot afford to lose even 1% of voters, which will push them in the center and reduce polarity. So kind of going back to your comment about polarity. But do you mind if we move forward? Because we do have another question regarding something a little more Ohio specific.
Yeah.
Talk in the chat asks, why didn't Ohio let independent people continue when they were redistricting? Should DeWine's son have recused himself? Is their question.
Okay, well, I probably am a little more up to date on this than Gene, being an Ohio resident. But I'm not 100% sure I understand the first part of the question. Why didn't Ohio let independent people continue when they were redistricting? It may be referring to one of a couple things. The redistricting commission by design doesn't have independence on it. Again, it's going to be, unless an independent were to win one of the 3 statewide offices that make up part of the committee: governor, auditor, secretary of state. But the question may be asking about the fact that for a time the commission hired a couple of independent map makers, people who I think are known to both Gene and I know at least one of them is known to both of us, to draw maps. And at some point, having paid these guys something like $89,000 or something like that, the commission simply decided that they weren't interested in their work and adopted another plan that they drafted themselves, primarily with the Republican staff in the legislature. I can't say why they did that, whether they felt the work wasn't proceeding rapidly enough, that they just didn't like the plans. You know, again, ultimately the authority and the responsibility for drafting a map resided with the commission. And so I don't really know what the reasons are. It's an interesting question. I'm surprised it hasn't gotten more attention from the press. The other part is, should DeWine's son have recused himself? This is a tough issue. The argument would be that because the governor is on the redistricting commission or appoints a delegate to it, that therefore his son has a conflict of interest in ruling on the work of that commission. I think that you know, the question of recusal is always a difficult question. There are legal ethical standards for when you must recuse, which is fairly rare. Office holders can always choose to recuse anytime they think that that it would be beneficial for them to recuse themselves, that the public perception would be bad. And again, I can't speak for Justice DeWine at all. My personal feeling is that he was probably fine to go forward. I have been in that position as a federal election commissioner, asked to recuse myself. At times I have. You know, he's one member of 5 on the commission. His father's one member of 5 on the commission. We don't know what was, you know, all debated on the commission and back in the commission. The results of the commission's actions don't directly affect Justice DeWine's own election. They don't affect his father's election. But just but I would say that one could certainly make the argument, just from a public appearances standpoint, maybe it would have been wiser for him to recuse. And had he done that, that would have resulted in another judge being appointed just to hear that case from the court. So those are questions to which I just don't have the answer, and I suspect, Gene, that you don't either. They're good questions, and ones that I think we'll just have to go unanswered, at least tonight.
Do we have any other questions or follow-ups to what was already said?
Yeah, please ask.
Oh, there is something in the chat here. Sorry. To what extent does instant runoff voting ameliorate some of the negative effects of gerrymandering?
Great question. So we in our field have an there's increasing research being done on this question. We have 2 states that have very recently experienced instant runoff voting, or ranked choice voting, as we call it. One of those states is Maine. So Maine now elects its Congress persons, but I think they weren't using it for the governor's office, and I think they may be now. Maine uses a ranked choice voting system. And the other state that has implemented, and it's just been upheld by that state's highest court just within the last week or two, is Alaska. So in Alaska, you rank 4 candidates, and then ranked choice voting is used to pick the eventual winner, both in the primaries and in the general election. The first things first, ranked choice voting systems are not all the same. We actually have a Nobel Prize winner named Kenneth Arrow who pointed out that when you rank choice candidates, the method that's used is different. So sometimes we eliminate the candidate who has the fewest number of first place votes first. We eliminate that candidate, and then we take his second place votes, and then we rank them order. They're not all the same. But the theory is that these systems should have people kind of not allow fringe candidates to win. Now, let me just say something at the very beginning. No candidate has to get 50% of the vote in the first round for this to work, right? If some candidate does get 50% of the vote, there's nothing to rank order because that candidate has the most first place votes. So it's only if some candidate gets 40%, and the next one gets 30%, and the next one gets 20%, we take the candidate that gets the least amount of first place votes, and then we remove that candidate, and then we see the people that are ranked him first or her first, who would they want next? And then we move those votes over. In Maine, 2 years ago, we had this very interesting thing that happened where, it doesn't matter what their parties are, but a Democrat who received not the most first place votes, when the votes were re-ranked, he won. The election, became the congressman from one of Maine's 2 congressional districts. The Republican would have become the congressman. He didn't have a majority, but he had the plurality of votes, so he won 49% of the vote. And then the Democrat won 48 or 47%. And then when those other three percentage of the people, when their candidate was removed because there was some third party candidate, those votes were re-ranked and they all went to the Democrat, and the Democrat won. I think ranked choice voting has my own view, is that it has a lot of potential. The difficulty is in educating people about it and about how the system works, and getting them to rank the voters, down the ballot and so forth. But there are increasingly at the local level municipalities that are using it, and I think it has a lot of potential as long as voters understand it. And there's a long run up and a lot of education about educating people about how it works. But I think, the theory behind it is that it brings us together. It doesn't allow fringe candidates to win as much. So to give you just a very simple example, if there is some crazy running and 40% of the people want him, and let's say 2 sensible people, and the crazy gets 40%, and the sensible person 1 gets 30%, and the sensible person 2 gets 30%, that crazy would win in our plurality elections with 40% of the vote because he got the most votes. Now with ranked choice voting, those other 2 people running, they're not a threat to one another. And what we see, or at least I don't know, I haven't done this research, but I've read some of it. What we see is with ranked choice voting, campaigning tends to be a little less biting. It's a little less zero sum because you really want people to rank you at least second, even if you're not their first choice. So you tend not to be so partisan and strident. That's at least the theory behind it. I think we need to, to be honest, I think we need to see how it works in practice and have people, run more experiments using it. Because right now it exists in only small pockets in the United States, but it has been upheld. I don't know if Brad has thoughts on this.
Yeah, I'm more skeptical of ranked choice voting than Eugene is, but I do think it's something. Again, it's one of the strengths of our decentralized system that Gene mentioned early on in our presentation tonight, that states can experiment with, cities and municipalities can experiment with it. As regards to the immediate question, will it ameliorate the effects of gerrymandering? It doesn't really alter or go at the issue of gerrymandering. Gerrymandering is contriving districts to try and make sure that one party will be more likely to elect somebody. I think depending on the dynamics of individual districts and exactly how and why they're gerrymandering, it may have some effect, but I'm not sure whether that would be good or bad. I think we just get into a lot of particular issues. So I don't think one should look at that as a solution to the problem of gerrymandering, but rather, as Gene has just been describing, whether you think it might be a solution to other problems, I think that would be the better way to look at it. I don't think it's really designed as an anti-gerrymandering measure.
Please ask more questions. We're happy to answer them. Mr. Chin Parker, you look like you have a question.
Anyone else?
Do you have any questions, Lucy?
No, it's been quite informative. There's a lot of information, for sure. We do appreciate having your expertise here tonight. We also do want to respect people's time. So I know we originally said it was until 8 o'clock, and we did bump over obviously for questions, and it sounds like Gene and Brad are happy to take additional questions if there are any.
Sure, we're happy to stay around if folks have other.
Well, I thank those who have come and those who might be watching later on the video. And I thank you, Lucy, and always my friend Gene. It's fun to get together and do this. It's been good, and I hope it's been educating for people at least a bit. Thank you. And by the way, I also will say that if people really want to, you can follow up with me at Capital Law School. I am here in the Granville area and will be happy to talk more about these issues. So thanks.
We will put this video up onto our YouTube channel. For the Granville Public Library. It will take a moment to sort of clean up and edit, but we'll get it up there.
Thanks everybody for coming. Please feel free to reach out to us by email as well if we can answer any questions. Just Google us, and Brad and I have public emails, and you can email us, and we're happy to answer questions.
Great. Well, I guess there are no more questions. Lots of words of appreciation in the chat, but thank you very much for coming tonight, everyone.